Hello everybody, it's Joe from PrepAgent. I hope you're having a good day. Today is Monday and we are ready to go. Give me a thumbs up if you could hear me and we will begin. Hello everybody, it's Joe from PrepAgent. I hope you're having a good day. Today is Monday and we are ready to go. Thumbs up if you can hear me and we will begin. Okay, so it sounds like we are doing all right. So today we're doing vocabulary. As we all know, vocabulary is the foundation for everything. And we will start with the word vendee. What does the word vendee mean? What does the word vendee? Vendee, what does that word mean? Excuse me. Okay, so the vendee is the buyer. The vendee is the buyer. What is that OREE rule? What is that OREE rule? Okay, the OREE rule is the OR is the giver, EE receives, OR vendor, optionor, give or proprietor, EE lessee, vendee, grantee, give me property. Okay, EE receives, OR gives. So you have the vendee and the vendor. Vendor would be the seller, vendee would be the buyer. Are there any exceptions to that rule? Are there any exceptions to that OREE rule? What do you guys think? Are there any exceptions to the OREE rule? Okay, no, there are no exceptions to it. Good. Sometimes people think mortgagor or mortgagee is an exception, but it is not. It is not an exception. When you have a mortgagor and mortgagee, what is being given and what is being received? What is being given and what is being received? So with a mortgagor, the OR is the giver, and they are the giver of that promissory note, the evidence of the debt. Okay, and the mortgagee receives that promissory note or that evidence of the debt. Okay, everybody got that? It's not about the money, it's about that promissory note. Has everybody got that? So the mortgagor is the giver of the promissory note. Somebody wrote a counteroffer. Is that exception to the rule? And the answer is no. A counteroffer is not an exception to the rule because a counteroffer is a brand new offer. In a counteroffer, the offeree becomes the offeror. Everybody got that? In a counteroffer, the offeree becomes the offeror. Do you guys understand that? The offeree becomes the offeror. It's a brand new offer. Okay, next item on the board is estate for years. So what do you guys know about an estate for years? Estate for years. What do you guys know about estate for years? Estate for years. Estate for years is for a defined period of time. So when you see two dates like April 1st to May 8th, that's an estate for years. There's a defined beginning and end date. When you have an estate for years, does the tenant have to give notice to the landlord about when they are leaving? When you have an estate for years, does the tenant have to give notice to the landlord about when they are leaving? What do you guys think? When you have an estate for years, does the tenant have to give notice to the landlord about when they are leaving? What do you guys think? And the answer is no. Why not? Because they know when you're leaving the moment you move in. Does everybody get that? They know when you're leaving the moment you move in. So it is not necessary. Okay, what would a periodic tenancy be? What would a periodic tenancy be? What would a periodic tenancy be? So periodic tenancy would be like that week to week, month to month, things of that nature, week to week or month to month. Okay, and what would an estate at will be? What would an estate at will entail? What would an estate at will entail? An estate at will means it could end at any time. Everybody got that? Estate at will means it could end at any time. All right, and last but not least, an estate at sufferance. And Michelle, yes, a notice should be given with a periodic tenancy, for sure. Okay, estate at sufferance means what? Estate at sufferance means they're staying past the time they're allowed, which would otherwise be called a deadbeat tenant. A deadbeat tenant. So obviously, estate at will and estate at sufferance are not legally allowed. The ones that are allowed are estate for years and periodic tenancy. Okay, obviously you could agree upon anything. You can make an agreement. So I shouldn't say it's not legal, but you know. So an estate at sufferance is like a deadbeat tenant. Okay, all of these things, the estate for years, periodic tenancy, estate at will, and estate at sufferance fall under one category. What umbrella do they fall under? What is the umbrella that they fall under? What do you guys think? What umbrella do they all fall under? Less than freehold estates. Excellent. These are all types of less than freehold estates. Estate at will just means it can end at any time. I think Ruby asked me for that definition. It just means it can end without notice. Okay, so these are all types of less than freehold estates. Okay, next on the board, we have a tax-deferred exchange. What is that? So it's also known as a 1031 tax-deferred exchange. What is a 1031 tax-deferred exchange? Do you guys know? A 1031 tax-deferred exchange. What is a 1031 tax-deferred exchange? So what a 1031 tax-deferred exchange is is when you sell a property and you take the money from the old property and you put it into the new property. Okay, you postpone paying the tax because you're putting it into a new property. You're reinvesting it. How many days do you have to identify that property, and how many days to close the deal on that property? How many days to identify that property, and how many days to close the deal? So 45 and 180. Excellent. 45 days and 180. All right. Next on the board, we have a quitclaim deed. What is a quitclaim deed? Who knows what a quitclaim deed is? A quitclaim deed is when you immediately transfer ownership. Immediately transfer ownership. Immediately transfer ownership. Okay, so remember, a deed is there to be evidence of the transfer, right, guys? A deed is evidence of the transfer. So a quitclaim deed is the most immediate way to do it. Money is normally not transferred in a quitclaim deed. Now you could do anything, but basically it's just like signing over the property and putting in somebody else's name. Yeah, so you could add people. It's just basically there to change who's on title. It's an easy way to do it. Okay. Procuring cause. Procuring cause. What is procuring cause mean? What do you guys think? Procuring cause. Procuring cause, that just means it's the reason the person is there. They're the reason they are there. They're the one who brings the buyer. Good job, Rachel. What type of listing, what type of listing do you not need to prove that you're the procuring cause? What type of listing is it not necessary to prove that you're the procuring cause? What do you guys think? What type of listing is it not necessary to prove that you're the procuring cause? What do you guys think? And the answer would be exclusive right to sell. Exclusive wouldn't be sufficient because there's also exclusive agency, where you would have to prove it because the owner could sell it themselves. So the answer would be exclusive right to sell. An open listing, you definitely have to prove the procuring cause because that means every broker can go look for a buyer. Injunction. What is an injunction? What is an injunction? What do you guys think? What is an injunction? What is an injunction? An injunction is the court order to stop. An injunction is a court order to stop. Does everybody get that? It's a court order to stop. Amortization. What is amortization? What is amortization? Amortization. What do you guys think? Amortization. So amortization is the paying of debt in installments. It's paying down what you owe. Now, what is negative amortization? Who knows what that is? What is negative amortization? Who's ever heard of that? Negative amortization. What's that all about? So negative amortization is when you make your payments, but the debt goes up. The debt goes up. Debt goes up. Debt goes up. Okay, the debt goes up because your payments do not cover the interest. Payments do not cover the interest. Okay, fee simple defeasible. What is a fee simple defeasible? Fee simple defeasible. What is that? What is fee simple defeasible? Fee simple defeasible means there's a condition where you could lose the property. Fee simple defeasible means there's a condition where you could lose the property, such as no alcohol. So if you drink alcohol on the property, you lose the property. So you have the fee simple defeasible estate. It's a type of fee simple estate, which is the most absolute ownership. But is it truly absolute? When you have a fee simple absolute, is it truly absolute? What do you guys think? Is it absolute ownership? Or are there certain limitations even with a fee simple absolute estate? What do you guys think? Okay, and the answer is yes, because you always got taxes. Okay, so you got taxes, you got other government regulations. All right, so it's not just taxes. You still have things like building codes and other things of that nature. Fee simple estates fall under the category of freehold estates. Remember, guys, we got less than freehold and freehold. So under the freehold, you have freehold estates, fee simple defeasible. No, excuse me, a fee simple absolute, then fee simple defeasible. And you also have life estates, which is when you own property based upon somebody's life. Now, we did talk about less than freehold estates as well, and there were 4 of them that we mentioned earlier in this webinar. Let's see who was paying attention earlier. What are the 4 types of less than freehold estates that I discussed with you guys about 15 minutes ago? What were those types of less than freehold estates that we discussed? What do you guys think? What were the types of less than freehold estates that we discussed? There was 4 of them. Okay, let's write it in the chat. All right, so the 4 types of less than freehold estates that we discussed was estate for years, periodic tenancy, estate at will, and estate at sufferance. We discussed estate for years, estate periodic tendency, estate at will, and estate at sufferance. Those are the 4 types you need to know to pass your real estate exam. Testate. You have intestate and testate. Intestate and testate. What does testate mean? What does testate mean? And what does intestate mean? So you got intestate and testate. What do they mean? What do you guys think? Testate is with a will. Intestate is without a will. Good. Testate's with a will and intestate's without a will. What do you call a will that's entirely written by hand? Ooh, that's a tough one. Let's use been studying. That's our double or nothing question of the day. What do you call a will that is entirely written by hand? What do you guys think? What do you call a will that is entirely written by hand? What do you guys think? That would be a holographic will. A holographic will. Oh, nice job, Michelle, 85. Holographic will. She got that first. Great job. That was a tough one. Okay, an easement. Easement. What is an easement? What is an easement? What do you guys think? An easement. An easement. What is an easement? So easement's the right to use somebody's property to get to another. Okay, it's the right to use somebody's property, obviously with certain limits. You can't have like a parade across somebody's property or like a monster truck rally. Do those things still exist? Are there still monster truck rallies? I feel like that was more a thing of the 80s. Maybe I'm wrong. It was like Bigfoot and all these like weird, scary names on the trucks, which you can't repeat. Okay, so easement's the right to cross somebody's property. Is an easement and encumbrance? Is an easement an encumbrance? Is an easement an encumbrance? Okay, an easement is an encumbrance because encumbrance is anything that limits the property. Limits the property. Isn't it just like big trucks that run over crappy cars? I always remember those advertisements. Sunday, Sunday, Sunday. And it was this guy, like a really excited voice. Maybe I just don't notice it because I'm not like 8 years old anymore. But when I was 8, I thought I was like, wow, monster truck. Okay, mechanics lien. Mechanics lien. What's a mechanics lien? Mechanics lien is where you don't pay for work that is owed on your property and they could file a lien. Is a mechanics lien a specific lien or a general lien? Is a mechanics lien a specific lien or a general lien? What do you guys think? Is a mechanic's lien a specific lien or a general lien? Is a mechanic's lien a specific lien or a general lien? It's a specific lien, which means if they could take your property if you don't pay, just one property, they can't take everything else. Whereas general liens, they could take everything. Who could give me an example of a general lien? So mechanic's lien is the example of specific lien. I mean, if you don't pay, they could take that one thing. Can you guys give me an example of a general lien? So a general lien means they could take everything. A general lien means they could go after all your property. So an example of that would be like income taxes or a judgment. A mortgage would not be a general lien. A mortgage would be a specific lien. Okay, good job, everybody. What is a license? You guys are all about to get a real estate license, so we should all know what it is. What is a license? What do you guys think? A license. Who knows what that is? What is a license? A license is permission to perform an act on the land of another. It's a revocable right. Good. So like a parking ticket when you go into a garage at the mall, that's a license. A movie theater ticket, that's a license. These are all licenses. You're getting permission to do an act on the land of another. What is a listing? What is a listing? What do you guys think is a listing? What do you guys think is a listing? A listing is an employment contract to find a buyer. An employment contract to find a buyer. By the way, if you guys have not already, make sure to follow us on Instagram. We're posting up real estate facts every day. And in our stories, I'm posting real estate exam questions, so make sure you do that. It's just prep_agent on Instagram. So if you look up prep_agent, you'll find us there on Instagram. So make sure you check that out. Okay, functional obsolescence. What is functional obsolescence? Functional obsolescence. Functional obsolescence is something loses value because of poor design. It's a form of depreciation. There are two other forms of depreciation that you have to know for your exam. Okay, so functional obsolescence is depreciation because of poor design, such as 5 bedrooms and 1 bath. What are the other two forms of depreciation? What do you guys think? So functional obsolescence is due to poor design. For example, one bedroom when there's 5 bathrooms, or vice versa. They both be functionally obsolete. So the other two are physical deterioration and economic obsolescence. Physical deterioration and economic obsolescence. Economic obsolescence on your property loses value due to factors outside the property lines. Physical deterioration is when the property is falling apart. Marginal tax rate. What is that? Marginal tax rate. Marginal tax rate. What do you guys think? Marginal tax rate. Marginal tax rate is applied to the next dollar earned. It's just the amount paid on the next dollar earned. Okay, promissory notes. What is the promissory note? We actually discussed this earlier. What is the promissory note? What's the promissory note, guys? What's the promissory note? Promissory note would be the evidence of the debt. Promissory note would be the evidence of the debt. Good. We talked about that. We're going to talk about the mortgagor or mortgagee. The mortgagor gives the promissory note to the mortgagee. An exclusive right to sell listing. Exclusive right to sell listing. This is the one we discussed earlier. We're talking about procuring cause. So if you guys remember, this is the one we said you do not need to prove that you're the procuring cause of the buyer. That's an exclusive right to sell listing because you get paid no matter what. If a buyer comes, you get paid, and that's what that exclusive right to sell listing is. You get paid no matter what. And last but not least, what is intestate? Intestate. Intestate. We spoke about this before. We talked about testate and intestate. So we all should get this right. What is intestate? Intestate. Okay, intestate means that there is no will. No will. Remember, testate has a will. Intestate has no will. We discussed this earlier. So with that being said, this was a nice little vocabulary review today. I'll see you guys tomorrow in the afternoon at 4 o'clock California time, 7 o'clock New York time. You guys do the math for where you are in between. With that being said, this is Joe from PrepAgent with Adrian. I hope you guys get your week off to a great start. Thanks, everybody, for attending. I'll see everybody tomorrow. Bye.